I think the single biggest thing that I see is that, a lot of high income, you'd be amazed actually that the percentage of high income, high net worth people that don't even have a basic estate plan. And that can be pretty disastrous. People don't think through that if they've gone through a divorce and they die without a will, that their assets are going to go to their kids. And if their kids are minors, then the ex-spouse is going to wind up managing the money. And a lot of people would have a major problem with that. But I think even more fundamentally, what we see over and over again is that the public doesn't really understand that the legal industry has become very, very specialized. And I think that's good for the public. I always tell people that if you were having a heart attack, you wouldn't go to a podiatrist. And I think the public generally realizes that there are specialists in medicine. Well, the same is true really in estate and tax planning. In Louisiana, for example, I'm a board certified expert in estate planning. There may be 150 of us in the entire state. I also have a master's degree in tax law. And I don't say that to be bragging. What I say to that is that this is all we've done for 23 years. And it is a highly specialized area when you're dealing with people's wealth. And unfortunately, a lot of the public doesn't realize that. So they'll go to their friend that's a lawyer, maybe their neighbor. Even among some of the specialists, frankly, I think there's things that can often be improved upon. So, we see a lot of attorneys that'll draft a will that doesn't even have any trust provisions. Well, typically we advise our clients to set up trusts, testamentary trusts, which are trusts inside the will for asset protection purposes. Even if the kids are mature and responsible, in order to protect that wealth, I know a lot of clients, that's a really important goal. Second is that when we do see wills that have trusts in them, a lot of times we see what's called ages and stages in it. So in other words, the trust might say at 25, the kids get a third of the trust, and at 30, they get half of the balance, and at 35, they get the rest. It sounds good in theory because the idea is, well, if we give them some money at 25 and they blow it, then hopefully they'll learn from it by the time we make the next distribution. What people aren't realizing, unfortunately, is that typically the parent's estate continues to grow. So if we've got a client with, let's say, a $9 million estate and 3 kids, and they die, that means that each of the kids' trusts, if they get treated equally, have $3 million. Do you really want a third of a $3 million account coming out to your 25-year-old? Some people are going to say yes, but the overwhelming majority don't want to take that kind of chance. We don't know who they're going to be married to. They don't know what their lifestyle is going to be like. It seems to me that it's much better, instead of forcing distributions out of the trust, to actually, allow the trustee very broad discretion so that they can fine-tune it based on the future circumstances that nobody knows. So we've got clients, a lot of our clients that have great kids, they're mature and responsible. Unfortunately, we have some clients that are facing challenges, kids that have substance abuse problems, kids that have been sued multiple times, kids that have been through multiple divorces. The family wants to protect the wealth. The wealth isn't going to be protected if you don't have a trust, if you don't have, good provisions in there. In our trust, we have everything from provisions that allow the retirement accounts to go to the trust and still be asset protected. There's some case law out there that if you don't name your trust as a beneficiary, that it can potentially, the inherited IRA can be taken, for example. People don't realize this, and a lot of the attorneys that just might do a little 1-2 page will, they have no idea of all the stuff that they don't even know that they don't know. So they think they're helping the client, but they really don't even realize it. And again, it'd be like the podiatrist trying to perform open heart surgery. It's just not really smart. And some people may think that that's kind of stating it, but this document is going to govern everything you've worked your whole life for. And I think it's really critical that you invest the time and money to go to somebody who's really good at this to make sure that all these loose ends are tied up. I mean, we have things like interim clauses in our wills that say if anybody challenges the will by claiming that, you were mentally incompetent or that somebody, forced you to do this will, that person's kicked out so that we can try to avoid litigation and the succession. We have S corporation provisions so that the trust can, be a qualified S corp shareholder, that your average attorney is just simply not going to even know that these issues can arise and cause all sorts of problems for the family. So please make sure when you're doing this, if you love your family, you love your life, and you love everything that you've worked so hard for, make sure that it gets done properly.